My name is David Postalski. I'm an intellectual property and patent attorney and partner at Gearhart Law, which is the firm that kind of sponsors and kind of puts this on. I in particular are all about kind of education and empowerment and making sure that everybody is kind of on the same page when it comes to this stuff, especially, if and when you ever become our client or somebody else's client. We just want you to be empowered and know exactly what you're getting yourself into. All of our topics that we've been doing, probably been doing this for about 3 years now. And so you can see all the recordings at our YouTube site, but we're always looking to create topics that will benefit all of you as entrepreneurs, creators, inventors, and stuff like that. I'm super excited to share today's spotlight with Stephen Friedman. He's going to take a moment to introduce himself, but I personally want to say that Stephen was just admitted to the bar, and he's a brand new attorney. He's been working with us for years. We're super excited to have him. He's amazing, and I'm so glad that you're all going to kind of get to experience him. He is definitely our kind of copyright guru, and so you'll hear from him. I'm going to turn it over. It's going to be a kind of presentation between me and Stephen. He has some slides. He will put them up, but we try to keep this very informal. We encourage your questions. Hopefully we'll get to them as they're coming in, but don't worry, this is all being recorded, so we can always follow up later, and we can always, again, have a one-on-one. So I'm going to turn it over to Stephen for now. Stephen, please introduce yourself to everybody.
Hi everyone. Yeah, I'm Steven. Thank you, David, for the introduction. Very nice. As he said, I'm an attorney at Gearhart Law. Yes, I was recently sworn in, but I've been at Gearhart for a few years now. My whole kind of academic professional career has been here, so very excited, very happy, excited to be here, talk about copyrights. There's a lot of you here, very exciting, and everyone seems to have a very different kind of specialization and area of knowledge. And some people, know a lot about copyrights already. Some people don't know so much. So I'm excited. This is kind of going to be, the slides I have are kind of going to be a broad-ish overview, copyright 101 kind of thing. But like David said, we try and keep it very informal, very much like, if you have a question, throw it in the chat, and we'll be monitoring the chat as I talk, and we can hopefully hit on the questions as we go, or if not, we'll get to them towards the end. Yeah, like I said, this is going to be copyright law kind of 101 overview of the foundational kind of concepts of copyright, and hopefully that you can take this home, whether you're an entrepreneur or you're a creative. Hopefully all of that kind of gets baked into this and everyone learns something. So I think we should start with, since this is a foundational kind of talk, we should start with the foundation of copyright. Where does it come from? Copyright comes from the Constitution. It was baked in right at the beginning. Article 1 of the Constitution, if you don't know, was details all the different all the powers that Congress has to regulate in the United States, and Section 8 gives Congress the power to regulate copyrights, patents too, but today's about copyrights. It says Congress will have power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So what do we learn from this? Mainly, we learn the reason that the United States wants to protect copyrights: to promote the progress of science and useful arts. The whole point of copyright protection in the United States is to incentivize artists and creators to create art, and do this because we believe there is value in art, there is value in kind of the progress of art, and there's a reason why we want to protect artists financially and economically by making sure that their art doesn't get kind of unjustly copied or infringed upon. There is some talk about, why is this the whole reason? For a lot of artists, the reason they're doing art is not for the money. They don't do it because they know they're going to get a copyright for X number of years and be able to financially exploit their art. They do it for art's sake. And so, there's some discussion about that. In Europe, there is what is called moral rights, which gives you copyright protection, not for the reason of incentivizing art to be created, but because they want to protect people solely for the work that they put into their art. We don't have that in the United States. It's just the way our law is set up is different. I guess kind of our country is kind of built on incentivizing creativity and economic activity, and that's kind of how that's baked into the Constitution, and it's baked into our copyright law as well. So that's where copyright law comes from. The Constitution originally. There have been several acts from Congress that kind of define copyright law more specifically, and how it kind of is, all the nuances and all the protections and all the formalities and all that stuff. Right now, the latest Copyright Act, the Law of the Land and Copyright, is the Copyright Act of 1976. It is available online in full. I'm not going to call it a page turner. It's quite long. If you're a bit of a copyright nerd like me, then maybe you want to check it out. But it's all online. You could look it up. There's a lot in there, and pretty much will tell you all you need to know about copyright. So let's start. What is a copyright? Copyrights are intellectual property. It's this intangible kind of idea that someone has that, it's not like it's not property like, a building is property or something like that. It's an intangible property that you own that gives you certain rights, which we'll get into later. But what is it? What does it protect? Copyright protects artistic works. This, artistic work might kind of be a loaded term. It can mean a lot of things. Like we were talking about earlier, code can be an artistic work. There's obviously the more obvious ones, the traditional arts, writings, etc. But artistic work, it can mean a lot of things. The government and copyright law doesn't really want to get into what is art, what isn't art, where is the line between art and not art. There's a very low bar. So the key of copyright is that you're creating something original. Originality has this low bar for creativity, minimum creativity, but you always need independent creation. The important part of copyright, the key, is that you are creating something independently. You're not copying anyone, and you're also not taking anything from what's called the public domain, underlying facts, just facts about the world that aren't really supposed to be owned by anyone. The kind of modern conception here comes from a case from the 90s called Feist, which is about this telephone company who they publish this telephone book, and some other telephone book copies all the information out of the telephone book. And so one of them sues the other one, says you copy the telephone book, but obviously you can't have a copyright in phone numbers, right? Those are facts. And so, but the court says there's a difference between the facts underlying this and the kind of expression that goes into the telephone book. All right, that was a little bit nuanced and nerdy.
Yeah, Stephen, I just want to jump in here for a second, just to kind of break some of this down for some people, because we were talking about, there were 2 or 3 questions about estate planning and stuff like that. So as Stephen said, copyright is a form of intellectual property, which means it's coming out of your intellect, and you are letting the government know what your original creation is, and in exchange they are giving you the right of copyright. And other forms of intellectual property are trademarks and patents. And so the reason why I'm talking about this is because, like other forms of property, like if you have real property, if you own a home, then basically your home and the actual definition of your home, where your property line ends and begins, is actually filed with your local county office or something like that. It's the same thing with intellectual property, right? Intellectual property, real property, kind of the same concept. If you can take what your original work is and then file it with, and actually register it with the actual government, then that should be the actual physical, if you're kind of quote unquote physical description of your property. And so if you own property, just like you own a home, then you'll be able to control who is using it and who's stepping on it and who you want to keep off of it and stuff like that. The issue here with copyright, as most of you have kind of already alluded to, is that, you know, what is considered original. That's really what it comes
Mhm.
down to. You may think that what you are doing is original, because how hard would it be to ascertain that somebody else has independently created it prior to you? Hard. But in the end, it may not actually be as original as you think. And so that is one of the points about copyright that makes it so contentious. It's very different than a patent and a trademark, that you file it with the Patent and Trademark Office, and they take on the obligation, the Patent and Trademark Office, they take on the obligation to examine your piece of property, your patent and trademark, to determine whether your invention is actually novel or whether your trademark is really distinct. In copyright, there is no, there's not a lot of examination going on by the Copyright Office to determine your originality. There is some, don't get me wrong, and we'll talk about some examples. But the point is, you may think you're original, but you may not actually end up being as
Mhm.
original as you might think. And therein lies, you know, some of the issues related to copyright. So I just wanted to kind of put that out there. But yes, like other forms of, like other types of property, like real property, intellectual property, personal property, all of that can be in your will. It can be, you know, passed to your heirs. Ownership of it can be transferred. So for all those kind of asking about, like, you know, how do I do my estate planning? This is a piece of your property. The same way you're going to figure out what to do with your personal property, with your real property, your home. Yes, your intellectual property will also be available for you to, you know, bequeath or, you know, grant or transfer ownership to. So I just wanted to kind of throw that out there. Please,
Yeah,
proceed.
no, and you're right. Intellectual property is a form of property. You can do many of the kinds of things with quote unquote normal property and you can do that with intellectual property. And like you were talking about with originality, I'm going to get into that in 1 second. Someone direct messaged me in the chat, please explain minimum creativity more. When it says minimum, it really means minimum. It really doesn't need to be much. Like I was saying, the court and the government doesn't want to get into what is art, what counts as creative enough to be art. Really, all they want is that there is some level of creativity going into it, right? The key to understand is originality, and the key in originality comes in this dichotomy between ideas and expressions. Ideas are kind of basic facts about the world or kind of central ideas of what art could be. Expression is the way that you express those ideas. Copyright lies in the expression. Okay, I have an example here that comes from a real court case. It's about this woman who knitted a quilt with kind of all the letters of the alphabet and a few little designs. And, you know, someone obviously knitted a quilt that is somewhat similar with the alphabet and other designs, but kind of arranged differently. And what the court really gets into here is the difference between the idea, which is not protected, and the expression, which is. The idea is the alphabet and, you know, the American flag and a house, right? Those are ideas which you can't get copyright protection on. What you can get protection on is the way you express those ideas. So the way that she arranged the alphabet, the colors that she chose, the shapes, the places she put these symbols, that's what you get protection on in a copyright. So you have to, in pretty much all copyrights, there's going to be some point in the middle of ideas and expressions where you get protection. I have a few other examples, like, you know, for example, I want to write a book about a teenage wizard boy, right? That's an idea which is allowed. J.K. Rowling can't sue me for that. Suddenly, if I make it a book about a teenage wizard boy and his name is, you know, Fairy Fodder, then all of a sudden she gets a little bit more of a kind of standing on that case. There's a lot. Copyright is kind of a sliding scale. And there's a lot that you can get to between ideas and expressions. And there's always kind of these elements that you have to separate out of every little piece of work, right? There's something that belongs to the public and something that belongs to you when you express it in a certain way. And that's what a copyright is.
Yeah, Stephen, there's that famous, I think most people on this call will probably point to, like, oh, recipes. Recipes
Mhm.
aren't, copyrightable. Why? Because it is really just, the idea of like taking, 5 or 6 ingredients, a cup of this, a spoon of that, a pinch of that,
Mhm.
whatever. And so, the actual recipe itself lacks originality, but
Yeah.
if you take all of the recipes, if you're like Martha Stewart and you take all of the recipes and you put it into a book, and along with that book, you put some photos, you put some background information about how the recipe came to be. You talk about how it was like, kind of passed down through generations. Then you start to see the originality start to come
Mhm.
about. So you can definitely get a copyright registration on a book of recipes, but the recipes itself
Yeah.
aren't per se protected. And so that's kind of a kind of
Yeah.
I
That's
really
another
want to
good
get into that
example.
example.
It's another good example because you can also think about it this way. Copyright doesn't protect anything that is solely functional, right? Something solely functional is not art, it is separate, right? So the recipe itself, you're not going to get protected. But if you present the food in a particular way, if you have this kind of really distinctive way that you put this recipe together and you present the food in a particular way, you might be able to get a copyright on that, depending on the expressive parts of it, right? So there's all these little nuances in copyright that come about based on how you express things, even if those things are just factual. That's what I was talking about with the telephone book, right? Even if all you have is a book full of phone numbers, if you express it in a particular way, the way you arrange the phone numbers, whether you put pictures or something like that, the font you use, those things can be protectable, even if they're tiny little details. Someone direct message me in the chat. Can I explain the difference between copyrights, trademarks, and patents? That's a big one.
Uh, okay, but very briefly, we'll say that patents are all about science. And so, for instance, if you have an invention that's based in chemistry, physics, biomechanics, electric, computer science, even in design, botany, geology, then you describe it in a technical and scientific way and you file it as a patent application so it can protect that invention. A trademark is all about commerce. It's all about creating a source identifier, a logo, a word, a smell, a taste, a sound, anything that appeals to the 5 senses of a consumer. If you can take that thing, the logo, again, the sound, the smell, the word, the colors, and actually file it with the trademark office and let the trademark office know that you are selling a good or a service under that logo or word or whatever, then you are able to get a trademark. Copyright is all about the artistic and creative expressions that come from our mind. So as patent is in science, as trademark is in commerce, copyright is all about the artistic and creative expressions. You may have something that fits all three. Like a lot of people can have that. They can have an entrepreneurial journey that they have something patentable that they're also branding and that also maybe has some sort of unique kind of design or marketing attached to it that they want to protect as a creative or artistic work under copyright. So those are kind of the kind of three main differences. I don't know, Steve, if you
Mhm.
want to maybe add anything there.
Yeah, I think in one word for each, copyrights are art, trademarks are brands, and patents are inventions.
Yeah, love
It
that.
gets a lot more detailed than that. We have, I think, 2 ESSs ago, you did like a kind of differences between all the three of them and myths and facts. And so go watch that YouTube video if you want more kind of nuanced ideas there. Someone else in the chat said, you keep talking about getting a copyright, but my understanding is that a creator's creative expression is copyrighted when it is created. Yes, very smart. Yes, you're right. Technically, your copyright comes into existence the second you fix it in a tangible medium, which means if you're, writing a book, the second you put that book down on paper, technically you have a copyright, right? The difference, when I say getting a copyright, it was a little bit colloquial when I was talking about getting it in food or something. What I meant is proving the validity of that copyright versus it being more of an idea and or expression. When I say when you say getting a copyright, as far as registration goes, we are going to get into that in a few slides. But the idea is, yes, you get your copyright the second you fixed it. It is technically your property. Registering your copyright comes with various other benefits that we'll get into, and is also very important, especially when it comes to lawsuits and that kind of thing.
Yeah, can everybody put themselves on mute? Alicia, can you just make sure everybody is on mute, please? Thanks.
Okay, a bunch of other questions. The cheat sheet expression of those three, right? What I said was trademarks are brands, copyright is art, patents are inventions.
Yeah, and then I want to just add one more thing to Marjorie's comment. You're right. Again, the three forms of intellectual property: a patent you apply for and it's awarded to you, right? Especially if your invention is truly novel. A trademark you apply for, it's examined, and it's awarded to you if your trademark is distinct. A copyright is the only form of intellectual property, like Stephen said, it's automatic. Paint to canvas, done, my copyright. May not be original, right? Keep that in mind. Paper to, pen to paper, I write a poem, it's mine, it's automatic. The only thing you have to do is to register your work. That you must do. But again, the registration process will require that your work is original. So even though you might be putting a social, to the next comment there, even though you might be drafting an awesome social media post, it may not be original. Yeah, you might have the automatic copyright, but you may not be able to get the registration to do what you need to do later to try to stop someone from taking that post that you just created on social media.
Yeah. I mean, so yes, someone asked about the social media posts. We would need to get into a bit more specifics. What is the post? What are you doing? But essentially anything creative that you put down into the world is right away a copyright. The problem is you have to register that copyright if you really want to protect it. If you really want to protect it, you have to register it, and we'll get to that. I wanted to talk about some other kind of formalities, technicalities in copyright. Duration. If you remember, the Constitution said that we are only securing these arts for a limited time. Copyrights don't last forever. They do last a long time. Right now, under the current act, don't ask me about the last act. It is extremely complicated and you don't want to know. Under the current act, copyrights last for the life of the author plus 70 years. That means whoever the author is, the copyright will last for their entire life. And then after their death, 70 more years after that. When it comes to copyrights that are authored by corporations or anonymous authors, they just leave it at 95 years from publication. This duration thing, it comes into the news once a year, usually in January, when new things go into the public domain, the public domain is the word for copyrights which have expired, or generally things that can't get copyrighted. Recently, the recent one this year was the Mickey Mouse thing, which, important to know that we're really only talking about this conception of Mickey Mouse, the Steamboat Willie kind of cartoon, and all the other ones are still copyrighted because they came out later. Steamboat Willie is public. Winnie the Pooh came into public domain a few years ago. I don't know if anyone has seen that disturbing horror movie about Winnie the Pooh being a monster bear. That's an example of how once something goes into the public domain, really anyone can use it for anything. So someone could come out with a Winnie the Pooh horror movie, and they did. And so I talked about copyrights authored by corporations. That might not make a lot of sense to someone, because how does a corporation draw a painting? Really, this comes into play with the work for hire. The work for hire is the idea that a person can author something literally, as in a person can, draw a painting, but the technical author of the copyright can come up as a corporation. These come this comes up in two kind of situations. Number one, if the person is an employee, sometimes their work is automatically a work for hire. It's very it's kind of gets nuanced. Most importantly, you want a contract explicitly stating what is being created is a work for hire, especially if you're an entrepreneur and you are hiring someone to draw something for you, to make a brand logo, to write your website, I don't know, whatever. You want a contract that explicitly states this is a work for hire, because otherwise they are going to own the copyright. It is not the same thing as getting a license to the copyright. It is not the same thing as buying the copyright and having it assigned to you. A work for hire sets the corporation, or you individually sometimes, as the author originally of the copyright. And so the duration of the copyright is going to be based on your life or your corporation. If you just license it, technically that person is still the owner of the copyright. You just have the right to use it. It's not the same. It doesn't protect you as much. If you're an entrepreneur, we highly recommend the work for hire as a way to protect yourself. I can go into registration now, but there are a lot of
Stephen, I
questions
wanted
in the
to,
chat.
if we can just break that down a little bit. So if you remember, you heard that copyright is automatic in the creator.
Mhm.
And so a lot of you are probably using, friends or family members or people that are just going to do awesome favors for you as fellow entrepreneurs to create things that might be eligible for copyright and or might want to factor into your intellectual property strategy. So if you can understand the issue, if that's the case, if copyright is if the copyright is automatic in the creator and you are asking a friend to create something for you, then make no mistake about it, that friend is the creator. They own the copyright. The only way it is transferred to you, right, for you to own, for you to get investment on it, for you to claim it as your intellectual property, for you to file the copyright registration, the only way it's going to be transferred from that creator to you is through a work made for hire. It's not through an email. It's not through an invoice. It's not through a promise. It must be in a writing that is signed by the person who created it, that they understand that as the creator, they are literally giving you the rights to control the thing that they created for you. So I'm not saying you can't use your friends. You can't hit somebody up for a drawing or something like that. Of course, but get them to sign a work made for hire, even if you're not paying them anything, right? Even if you're paying them $1, right? It's such an important document. I can't tell you how many companies we work with that are startups that this trips them up, because when they're going up against due diligence by an investor, and the investor's now asking, how did you create your logo that you filed the trademark on? How did you create this, that, and the other thing? And he has to say, well, my sister's brother's wife did it for me. Excuse me, your sister's brother's wife owns it, and now we need it. And so you need to get a work made for hire to avoid all of this. It's just a simple thing, right? Just get a work made for hire. But now you can understand how it gets a little bit more complicated for those of you that are using like Fiverr, right? Great, people do it. But in Fiverr, if there is no understanding or obligation that the graphic designer who created something for you actually understands that you are going to be the ultimate owner of that thing that they created, right? Because there's probably no work made for hire between you and Fiverr unless you reach out to the consultant, unless you reach out to the actual consultant directly and ask him to sign something. But now you can understand how this can kind of cause a lot of havoc when you're trying to claim ownership and protection for something that you think is yours. Yeah, I just wanted to kind of play that out a little bit.
No, I think that was very good. We have one question in the chat directly about work for hire. If you are hiring a company, do you need the work for hire with just the company or also the employees? If you are contracting this company to create something for you, the work for hire A well-made one will have built into it that it includes all the employees, et cetera, of the company, and will have, the company, you only need one with the company, but a well-made contract will cover the employees as well. Jenna asked about registering her works before she puts them on social media.
Hmm.
And she said she has hundreds of pieces of work. Should you register each piece? And so let's talk about registration. Registration is important for the main reason of you need it to protect your work. You can't sue someone in federal court if you're not registered with the Copyright Office, and you can't get statutory damages in a lawsuit in federal court unless you were registered before the infringement happened. It's very important, especially for smaller artists. Statutory damages are going to wind up being way higher than the actual damages you could get if you didn't register before. And so if you really want to protect yourself and want to expect some kind of compensation if someone copies you, register before. You mentioned you have hundreds of pieces. Do you need to register each piece? It's complicated. It depends on a few things. Someone said you can bulk register many artworks at a time. Yes and no. It depends on what kind of artwork it is and whether it's published or not. Unpublished art can be registered in large groups a lot of the time. Published art more often is either limited to small groups or one at a time. It also depends on what kind of work. Photographs have bigger, you could register more photographs all at once. It's going to be very context dependent. And so, we would recommend getting, kind of specific advice for your own situation. You can also register as a collection of art, which is different than registering as a group of individual pieces of art. So it gets really nuanced and detailed. So, it really depends on your particular situation, what you published, how you published it, what the art is. It's tough. I agree that it doesn't make a lot of sense sometimes if you have 500 pieces of art to make a $50 registration on each individual one. So we would recommend consulting with, a lawyer that knows how to get a cost-efficient way of registering these works.
Yeah, that's actually a great way to put it. Jenna, and to all the artists out there, you also have to look at it as like the cost of doing business. Right now, you have 100 pieces of original art, but most of the artists that we represent, we've kind of you kind of have to be trained a little bit to create, register. The longer you wait to register, the harder it might be to prove that your piece was original. There's that. And then second, I want to say one thing: the Copyright Office is not stupid, right? At the end of the day, they know that, you're going to try to group pieces together and that you're probably going to try to do it efficiently or economically. You might be doing it on your own. Many times the Copyright Office will push back at you and say, well, there's really 10 individual pieces here. They're each worthy of its own copyright. And so you need to split them up. That happens. It definitely happens. I mean, ideally, it's one copyright per one work. I mean, ideally, that's how it should be for maximum protection. I get it. That's hard. That's expensive. So to adopt Stephen's kind of strategy, yeah, there are ways to group them together, but know that the Copyright Office usually has the last word on it. They're not looking to give one piece that was created 3 years prior to another piece more protection than the other piece, right? Because it's all about, your protection starts from creation. So if you grouped, 100 pieces, but one of them was created 20 years ago and one of them was created yesterday, the Copyright Office is not going to give you 20 years protection for each. They're not going to give you the creation date for all of those pieces from 20 years ago. That's not fair. You created one yesterday. So, keep in mind, you may have to you might have to sacrifice some of the copyright term, your copyright protection term, if you start to group pieces together that shouldn't be grouped together. Again, if you're doing this on your own, that's some of the risk you run. If you're probably working with an attorney, there might be a way to kind of, strategize around this.
Right. So hopefully it became clear that it is very nuanced and, it depends on fact-specific circumstances for all that stuff. I saw a question in the chat about the difference between owning masters versus copyrights. I assume you're talking about music. Masters is kind of colloquial term in terms of copyright law, as far as the difference. Copyright in music is a little complicated because there's kind of two copyrights in a song. Usually there's a copyright in the composition of the song and a copyright in the performance or the digital recording of the song. And that can even be three. Masters usually refers to the original digital recording of a song, right? And the copyright in that. And so a lot of the time in music, those masters are split ownership between the artist and the publisher, the artist and the label, something like that. And so in music, it gets even more complicated because there's, copyrights are kind of in two parts or in three parts, and it gets really complicated. Honestly, music copyrights could be its own ESS probably.
Yeah.
Okay, moving on. What does a copyright do? We kind of alluded to this earlier. A copyright comes with 6 exclusive rights. This is the basket of rights you get. Reproduce the work, prepare derivative works, distribute, perform, display, also perform. Perform shows up twice because, again, there's a nice little music is even especially complicated in copyrights. So perform comes up twice, specifically talking about playing something on the radio or some kind of audio transmission online. Reproduce is generally the big one, which means you can't reproduce it. You can't copy it and put it somewhere else, or a copier can't copy it and put it somewhere else. This basket of 6 rights, if any of them is violated, that's what triggers copyright infringement. Copyright infringement, the formulation is a little basic. Do you own the copyright, and was it copied? It's not really that basic because we just spent 45 minutes talking about, do you own a copyright? And copying itself is also very complicated because, sometimes there's the obvious case, which is someone literally copied your work, they copy pasted it, and you could see it's exactly the same. But most of the time, it's a little bit more nuanced. Something's very similar, but you don't know if they actually copied it. It can get complicated. And so copying can be shown circumstantially through access plus what's called substantial similarity. If a work is very similar to your work, please don't draw on the screen. If work is, you can kind of show someone is copying the work if you could show they had access to your work and what they produced is very similar. That's kind of the second element of copying. That's how you could prove it circumstantially. And that's kind of copyright infringement lawsuits. We had a question in the chat earlier about fair use. I don't remember exactly what it was, but it's the most common copyright defense. It's probably the best copyright defense because it's kind of an absolute defense if you could get it. But it's kind of a mess in terms of many people have many different conceptions. What is fair use? What does it all mean? There's a lot of competing kind of ideas out there, and it's very commonly talked about by people who don't really know what it means. Again, fair use is complicated enough that it could probably have its own ESS, but there are 4 factors that the court talks about. Number 1, the purpose and character of the use. This is really the big one. A lot of times it's referred to as transformativeness. How much did you change the work when you used it? Why are you using it? Are you doing it for educational purposes, for critique, for news, for journalism? All of these things weigh towards fair use. For example, if you're a teacher and you want to use an image that you found online that is copyrighted, but you're using it solely for educational, non-commercial reasons, the court will probably say that's fair use. That's kind of a quintessential fair use case. And then the other 3 factors kind of also all play into it. The nature of the copyright, the more creative a work is originally, the harder it is to show that it's fair that you used it, because it required more expression. The amount of the work that you use, kind of self-explanatory. The more you use, the less likely the court is to buy that it's fair that you used it. And the effect of the use on the market. If what you used is kind of substantially impairing the market for the original work. And the court isn't going to say that's very fair.
Yeah, you know,
Um,
I
yeah.
think we need to break this down a little bit too, because I think most people that use other people's work, and I'm sure there are people on this call that will Google something and you know, they'll take somebody's image and they'll use it on a presentation, or they'll use it on your website. Or we heard someone earlier say, you know, I took some excerpts from a biography or an autobiography or something like that. I think I think what we want you all to know is that fair use is a court-ordered decision. It's
Mm-hmm.
not for us to meaning it's not for the creator to say, "Oh yeah, it's fair." Oh yeah, the way that I'm using it is fair. Oh, I'm just a teacher. I'm going to use it. It's fair. Oh, I'm not making money from it. It's fair. Oh, I'm just posting it on my website. It's fair. Oh, I'm just reposting it on TikTok. It's fair. No, like at the end of the day, just know that usually you should have you should have some sort of attorney kind of weigh in as to whether your use is fair, because like you probably should have an attorney weigh in on whether your use is fair before you use it. Because if you use it and then get some sort of cease and desist letter or sued from infringement, then what you thought was fair may not actually be fair, and the court may say that it wasn't fair based on the based on these 4 factors, and then you're liable for damages. And so it's definitely a slippery slope. It is definitely the wild, wild west out there a little bit. I mean, the internet and social media has caused havoc with this. Everybody sees everybody else doing something. And so I'm just going to assume it's fair. But people watch, right? Companies watch, creators watch. And I think what I want all creators to know that are out there, if you don't want your work to be taken by someone that is assuming that it's fair to take your work, then don't take somebody else's work. Then don't assume that somebody else's work can be taken. It is so easy in today's world to find out who owns what, where, when, and how, and simply ask them for the rights. If they say no, move on to something else. Right? Move on to something else. Move on to something in the public domain. Move on to an owner that will give you the rights. But to just take it and assume it's fair, that's an expensive assumption. We see it all the time. Don't do that, right? I would rather you talk to an attorney, get some sort of opinion, and don't come to these conclusions themselves. Because again, this is what a court determines.
Yeah. And because even if you're right, and it is fair, even if you're right, some companies will still come after you and ask for money, and then you'll have to defend yourself. You're not going to be able to, get the court-ordered conclusion that a use was fair without legal fees. And so a lot of the time, even a fair use is going to cost you, right? Even if at the end of the day, you're wind up, able to kind of get those legal fees back in court, it's going to cost you for a long, long time in legal fees proving that it's fair. So even if you're right and it's fair, you probably still want to ask permission a lot of the time, or try and find kind of a public domain art, something like that. We have a bunch. Yeah. I don't know if you want, I had a bunch of questions in the chat that I
want to just say one more thing. I think we should get to them, but I want to say also, I think the rule of thumb, is that if you are taking somebody else's work to make money off of it, to use it for marketing, to draw clients to you, to sell your own products, to kind of market yourself, then the moment that commercial aspect comes into play, you have to look at it from the eyes of the original creator. Should that money have, should that money that you're using my work to make, I should probably get a piece of it. And so of course I'm going to come after you. So the moment it becomes commercial, that rule of thumb, the moment you're going to use works to do something commercial, that already is red flag. Don't get me wrong. There are plenty of teachers who don't make money, like, kind of use works in their classroom and assume that's fair use. I'm not really making money other than the fact that I'm just being paid as a teacher. And they also get, dragged into court. So again, it's just a kind of rule of thumb, red flag. Don't make any assumptions. But if you are using somebody else's work to kind of create a commercial aspect to something, danger, Will Robinson, do something else.
Yeah. And quickly, there were questions in the chat about how do I go about this? What do I do? Most, a lot of the time we're talking about photos or pictures and stuff like that. Most of the authors will have a licensing portion on their website, or it'll link you to like Reuters or iStock or something like that. And you can literally just buy the license online. Um, a lot of, in other cases, you just want to, send out an email, ask for permission. Sometimes you want to get a lawyer and get a more formal licensing contract. Actually, I'm going to say most of the time, if not all the time, you want to ask for a lawyer to get a formal licensing contract, especially if it is kind of, your livelihood that you're trying to make sure is all protected and squared up. Okay, other questions in the chat. Someone asked about AI, AI plagiarizing, AI generated images. First thing I'll say is that we had a whole ESS about AI a few months ago. Go look at that one on YouTube for more detailed information than I'm about to give you. Generally, if an AI is creating a piece of art, it doesn't get copyright protection. The Copyright Office has come out and said AI is not a human and therefore it cannot get copyright protection. It's not saying what's art or not, but the law requires human authorship for the grant of a copyright. AI plagiarizing creations is very different. That can happen a lot. There is the element of, okay, so in the first place, there is AI plagiarizing creations in terms of using them to learn. That is an ongoing lawsuit. I think Google is suing them and the Authors Guild is suing them. And by them, I mean OpenAI, for using their works to train their AI. The second thing we're talking about is if AI kind of used your work and it spits out something that is very similar. If the person that is using that AI work is doing so in like a commercial way, yes, potentially they are liable for copyright infringement, which is also why we say be careful when you use AI to create art or something like that, because you can be unintentionally infringing someone's art if that AI was trained on that art and is creating something similar, even if you don't know it. You don't need to know that you're infringing someone to be infringing someone. You could still get sued or, sent a letter or something like that. Other stuff, life story. Okay, you answered that in the chat. Self-published book on Amazon. Yes, it depends on, the contract with Amazon. I guess I'm not totally familiar with how Amazon does the self-publishing kind of thing. But yeah, it's very possible that Amazon in their contract terms, gets ownership of the copyright for helping someone publish. It's possible. We'd have to look at the contract. Yes, the recording will be made available. It'll be on YouTube later.
Do you see Dr. Ford's question? How should we go about asking to use the rights to the other parties?
Right. Yeah, I feel like I was saying, you either want to, it depends on what it is. A lot of them will have kind of a link directly on their website, like a creative will have a link directly on their website, license my work, the bigger photo and picture ownership kind of companies will have, you could buy them directly online for X amount of dollars for X amount of years. A lot of artists, you can just email and ask for a license. Sometimes they'll have stock licenses that they give out to everyone. A lot of the time you'll want a lawyer to kind of look over it, or you want a lawyer to create a licensing agreement from scratch for you for a particular situation. It depends on the context and everything you want. So hopefully that helps. A lot of other questions. How do you know if something is in the public domain? Good question. I mean, like we were talking about, if it was created a very long time ago, based on those duration rules, it'll be in the public domain. If you're talking about just something you find online, it is usually safe to assume it's not. I would try my best not to just take anything off the internet and just assume it's public domain, which is actually the next few things we were going to talk about.
Yeah, there are also some great sites that track works that fall into the public domain. I think there's a few of them depending on the work, if it's literature or photos, whatever. So you can just do a quick Google search and you can search those sites and then you can see what's in the public domain and use that to avoid all of this mess about kind of fair use and infringement for sure.
Yeah. Someone asked about social media. TikTok, can you be sued if you use popular music and sounds on TikTok and other social media platforms for marketing purposes? Yes, technically. A lot of
Yep.
the time, when it comes to something like TikTok, if like everyone is using a particular sound, it'll be pretty difficult for for a company to sue, the 10 million people using a sound on TikTok, right? They'll probably target the biggest ones. If it's going to happen, they'll target the biggest ones and sue them. Technically, you're copyright infringing, and we aren't going to recommend it. A lot of the time, if you're small enough, you're just going to sneak under the radar, or at the very least, they're not going to think it's worth their while to sue a bunch of um, small TikTok accounts. But if you're a bigger company, you want a licensing agreement for everything you're using for marketing and promotional purposes, just to protect yourself. Do you need to put credits on something if you license something with agency? I mean, it'll depend on your contract, whether you need to credit things. We have some laws in the United States that guarantee an author's right to crediting when you use their work. It'll depend a little bit on the situation, specifically with photographs, I should say. It'll depend a little bit on the situation. And so, you'd want to get it kind of looked at based on your particular facts. The safe thing to do would just be to credit it because it doesn't really cost you much. But if you really don't want to credit it and you want to make sure you're being safe, ask a lawyer and give them all the kind of facts of what you're talking about.
Yeah, and
Um,
just
yeah,
one more disclaimer, because I see that I know there's a lot of comments about TikTok and YouTube and kind of social media stuff. Just know that's a big mall, right? That's the internet is the biggest mall we have, right? And so I think it's really important that if you are going to be using YouTube or using Snap or using Facebook, that you read the terms and conditions. All of the answers are probably right there for you to realize, like, wow, I put something on, I don't have permission, and somebody complains about it. My YouTube video is going to be knocked out, right? You see that all the time. You watch a video today and it's gone tomorrow. That's because somebody likely complained that they're using the image or using the music or something, and found it.
hmm
The person policing it found it. They may not find everybody right away, but if they did, then it allows YouTube and these sites to kind of take you down. So read those terms and conditions. We
yeah,
draft them all the time for businesses, and so each of them are unique in its own thing. But know that that it is the wild, wild west out there, and most of the time it's a catch-22. We know you have to use these sites to promote yourself, to market yourself, but the respect for intellectual property on those sites, getting better, but it's not really there, and so you
yeah,
run the risk. So you either want like 5 million people following you and not have any sort of protection on the things that you're putting, or not. That's what it comes down to.
yeah.
And
That's
yeah.
a good that's a good point that I forgot to touch on, is that a lot of these sites have takedown kind of requests that an author can submit. If he finds a video, they could just take it down and the site can do it without kind of any real review. And that's kind of more likely to happen than just getting outright sued, because that's a lot of work for someone. But a lot of these bigger companies, music labels, even have just like bots crawling YouTube that automatically submit takedown requests if they detect some portion of music that is, not licensed. Someone mentioned as the children of a musician whose work has been copyrighted in the 40s through the 80s, keep the copyright going for the family. That's going to be a loaded question. It depends on a lot of things, especially for works that were produced before the 1976 Act was passed. The duration on those is going to be extremely messy. And depending on registration in the Copyright Office, whether they were renewed, not to sound like a broken record, but you need it reviewed. Yes, copyright can be passed through your estate. And in theory, the heirs would assume ownership, but whether that copyright even still exists is kind of also a question, because of the way that the pre-1976 copyright law worked. He died in 83, so in theory, some of them are going to be active, some of them might not be anymore. You kind of need it looked at. Okay, there are a bunch of other questions and we're basically out of time. I just wanted to touch on the last thing that I had to say.
Yeah, please do, Stephen, if you can.
Um, the last thing we wanted to talk about is this kind of new trend that's happening in the copyright law universe, which is what we are calling the troll lawyers, the copyright troll lawyers, who are basically their business model is to retain clients that have large photo databases of copyrights. And nowadays, obviously the internet is infinite. There's a lot of places. And they will kind of crawl the internet with bots and other tools to find websites that use those photos or pictures, which were not licensed, and send out stock template letters asking the people who use those on their websites to take down the photos and pay them a whole bunch of money. And we've been seeing this creep up more and more and more and more. We're getting more and more letters like this. And so our biggest advice to entrepreneurs with this kind of thing is don't just take any photo you see on the internet and put it on your website. I mean, this especially applies if you're selling something on the website because of, like we talked about, fair use. But even if you're not selling anything on the website, you could still get a letter from one of these troll firms that is asking you for a bunch of money, even if kind of what you did is still fair and not a big deal. They're still sending out tons of these letters, right? Their business model is to send out as many as possible, and in the hopes that one or two come back with a bunch of money, that kind of makes them profitable. And it's just very dangerous out there to just take a photo you find on the internet and put it on your website, because you could wind up, even if you're not going to get sued, you're going to get a letter and then you have to get a lawyer, and a lawyer is going to cost money. So our advice, don't just take any picture you find online. Either A, license it like we were talking about, go to iStock or Reuters or whatever. And if you click on a photo, you can license it for X years for X dollars. Or take something from the public domain. Like we were talking about, either there's websites, if you type in like public domain images online, there's websites that kind of compile a bunch of images that are free to use. You can create your own. You can use AI with the caveats that we mentioned earlier of being careful. So that's how you protect yourself. Use your own stuff, license it, or use the public domain.
Yeah, and you can also check out creativecommons.org. This is a great website where you can use other people's work for limited uses or limited ways. That's also a great resource. Check it out for all of you that are artists that are okay, that kind of want your works, because that's also an artist. This is all an artist. This is all an artist and creative prerogative to kind of do what they want with their work. Some people want to control it. Great, excellent. That's what a lot of this was about. But some people make things so that everybody could enjoy. But at the same time, they want credit. They want to be they want to be associated with somehow. So listing your work on creativecommons.org and having a limited license so that the work could be used is another way to kind of get the best of both. You get your credit, but it's also controlled and stuff like that.
Yeah, Creative Commons is a good one. Someone mentioned Pexels in the chat, which I believe is another website that does that. I would say maybe Pexels does this. I'm not sure. Some of these websites also post like iStock photos that that require licenses, like alongside their public domain stuff. So double check whatever you're using is part of the public domain section of the website or whatever it would be.
Yeah, Steve, maybe we could, there was just earlier in the introductions, maybe we can talk about, because everything we've been talking about is the United States, right? This is how you get the United States copyright. Maybe we can talk a little bit about foreign registrations and like how that works.
Yeah. So it's complicated. Every country obviously has their own laws, and so everything is going to depend on where you're talking about. There was someone earlier, I think I remember what you were saying, someone earlier asked about what happens with the publishing rights in foreign countries. What does that mean when I give a foreign company the rights to publish something in a foreign country? Really what that means is that, you still own the copyright, But a lot of the time it's very difficult for you to, say you're here, it's difficult for you to publish and sell a physical book in Poland or whatever. So you contract a Polish publishing company and you give them a license to sell your copyrighted work in Poland, and they have to pay you a certain way. Usually it's through the use of royalties, which is you give them the license to sell the book and you make 50% of all the sales or something like that. Right. So that's kind of how that works. Foreign countries, a lot of them work differently in terms of copyright, in terms of how you get protected and whether you need to register your copyright. Like I said, they also have moral rights in a lot of foreign countries, which are about kind of the work you put into the copyright, and more so than, the idea that we want to incentivize things. And so a lot of countries say that you can't even license away those moral rights. And so they have even stricter copyright protection in, like, say, Europe. And so it's complicated. It depends on the country you're talking about, and you're always going to want someone to review those things that is kind of well versed in that area. Are we just
Yeah,
going to keep taking questions, David? What do you think?
yeah, I think we should taking questions, but there was a
Okay.
few other things I wanted to just talk about, just on the foreign side. So just
Okay.
know that there are international conventions. The one for
Hmm.
copyright is called the
Yeah.
Berne Convention, that says, well, if I have a copyright in one country, in one territory, let's say the United States, it may very well be given full faith and credit in another country. But to Stephen's point, make no mistake, if you wanted to bring a lawsuit in a particular country, then the requirement, and it was one of the questions up above, the requirement is to have an actual valid copyright registration. You can't really sue based on copyright infringement unless you have the corresponding copyright registration in the country where you want to sue. And so keep in mind, yes, it's automatic, but that's one of the benefits of registering in the territories where you're selling or marketing to, or might have the potential for infringement, is that so that if there is infringement, you're kind of set and ready to go and bring a lawsuit right away. So keep that in mind, and maybe we can talk a little bit about Stephen. I think earlier people were talking about like watermarks and how, kind of how that helps them.
Mm. Yeah, a watermark can be really useful because uh, I mean, it depends on what you're talking about, but like on a picture or a photo, it kind of makes it very difficult for someone to copy your work. If someone is copy pasting your photo and you could see your watermark, that is an indication that they are doing so without a license, and it makes it very easy to prove that kind of thing in court. It's similar to the reason you would give the little C, the circle C, like we have at the bottom of the PowerPoint there. It's a notice to the public that this is a copyrighted work and that you need a license if you're going to take it. It tells the court that you told everyone that. It puts them on notice. They can't say they were innocent infringers, which isn't a total defense, but can, minimize your liability in some cases. And so it's a very good idea to have watermarks or the little circle C on everything you have, just to put the public on notice and to make sure kind of everyone knows this is a copyright that I'm protecting.
Yeah, that's a good point. I also want to say, I want to go back to the originality for a second. I just a few years ago, I was involved with a situation where the designer that we were representing believed that their pillow design was unique and that it was original. And then so we got the copyright registration. Great. Remember, there's no examination based on originality. And we then discovered that one of the large furnishing stores, I won't say who, made a very similar design on these pillows that they were now selling um, in their stores, like, kind of nationwide, store. And so we reached out. We're like, we actually sent them a cease and desist letter and was like, excuse me, my client was the original creator of this design. She has her copyright registration. For all intents purposes, we believed it was original. And what happened? This is that the whole originality thing. That store was able to prove that they actually created that similar design 2 years before my client created theirs in a foreign country. And so here my client thought that it was original when really, she was 2 years too late, from that perspective. So, this is hard. Like, how do you like? There's no like. How do you search to see whether you were original or not? It's easy for a patent. There are patent databases. It's easy for a trademark. There are trademark databases. For copyright searching, it's expensive. It's not really effective. You can't really just search on Amazon or go into a store. Like, it's tough. So you almost have to throw sometimes caution to the wind, but know, and hopefully your belief in the fact that you were original can actually stand up to the threats of infringement that you might be, targeting other people for.
Mhm.
Um, so yeah, it's definitely a catch-22. Yeah, sorry. Yes,
Okay.
it's
No, I was just
uh,
gonna go through more chat questions, um,
great.
if we have time.
Yeah, please go for it.
Someone asked about companies that only charge $50 to do all the registrations on USPTO. I mean, do it at your own risk. Clearly these companies are, who are they? Are they lawyers? $50 is like the fee in the first place to register, and also the USPTO is the trade patent and trademark board, not the copyright office. So that's different.
Yeah, I also, we get this question a lot. Like, oh, can I file my own trademark? Can I file my own patent? Can I file my own copy? Yeah, you can do whatever you want, right? You can do whatever you want, but at the end of the day, this is how I say it. I'm not trying to be offensive, but I really do think it's like how it should be. Everybody
Mhm.
should kind of stay in their lane. I'm not going to go to my dentist to cut my hair. I'm not going to, right? I'm not going to do that. I'm not going to go to my, like,
That's a good
doctor.
one too. You
Yeah,
can
like,
cut your own. You could cut your own hair, but it won't be good.
yeah,
Um,
exactly. Then there's that. And then, like, I can't tell you how many times we see people that try to do it themselves and end up paying double or triple to undo what they thought they were doing themselves. But make no mistake about it, we definitely have clients that file their own copyrights, file their own trademarks, file their own patents, and at some point we get involved. But in the 20 years that I've been doing this, I find that the people that can do it themselves, great, but the ones that think they can, oh my God, they end up causing more trouble than they bargained for.
yeah,
That's all.
you wind up yeah. I mean, like you're saying, you can do whatever you want. All of these things are online. You can go on the website and register for yourself. But if there's a problem, not only there might be a problem in registration and you might get rejected, but if you didn't fill it out right, even if you get the registration, maybe you didn't register it correctly. And then when you go to sue someone based on it, your protection is more limited than you wanted it to be in the first place. And so, yes, you can do all these things yourselves. You could sign up for these like faux lawyer kind of companies, but you're not going to get the same kind of protection. You're not going to get the same kind of thoroughness that you get if you hire an actual lawyer to do this kind of stuff. Um, yeah, more chat questions, I guess. Are copyright laws going to be updated anytime soon since 1976? Yeah, they're updated all the time. Um, it depends on what you're talking about. There's constant laws coming out amending the 1976 Act for various different things. Um, Congress is slow. We know this. Congress is slow to amend laws and create new laws. And so they're going to be dreadfully behind, like on AI, like we talked about. Congress never actually passed a law on that. That's just guidance we have from the Copyright Office. But the 1976 Act does get amended a lot. It's just the kind of the core of copyright isn't really going to change much kind of in the foreseeable future, unless there's some kind of drastic shift in how we view intellectual property. The act before 1976 was 1909. So that should give you an idea of how long there is in a gap between these things. And so, it's amended here and there in the kind of the minute details, but the kind of core of it isn't really going to get changed much. Originality, could they check to see when you've created the work, like with the date created? Yes. they can. It depends on, because every time you submit a copyright registration, you have to deposit, you have to do what's called deposit with the Copyright Office, a copy of the work so they know what you're registering. And they also keep it for their records in the Library of Congress. And so, yes, in theory, they can check if the deposit you have is dated and you put a different date in the application. Yeah, they're probably going to check that. The copyright review process isn't the most stringent, like they're not super in depth on it, but they're going to check the dates. And so, yes, recommend putting the correct date on your application, the date you've created the work. And there's a difference between, I mean, hopefully you'll hire a lawyer, but if you're doing it yourself, there's a difference between when you create the work and when you publish the work, like we were kind of talking about earlier.
There's a question about global copyrights for music. You
Global
see that?
copyrights. Oh, I see. How do we protect our music? I mean, kind of like we were talking about, there are international conventions that say one country, all the signatories to this convention, this treaty, say that they'll recognize copyrights from another country in the treaty. It depends on the country you're talking about. Some of them don't have formal copyright registries. Some of them require registration on the copyright registry. It depends. And so, again, if you're targeting a particular country, you're going to want to, get that kind of looked at in particular. When it comes to streaming, yeah, that's more complicated because obviously the stream kind of goes everywhere, or not everywhere, but most places. And so there's that element of it. It depends on what's happening. It becomes very difficult as an artist in the United States who's streaming on Spotify or Apple or whatever to find a small infringer in some, obscure foreign country. It's pretty difficult to find and sometimes is not that damaging, but it depends on the country. A lot of them are going to be signatories to the Berne Convention, and so you can get some protection out of your United States copyright. Some of them may not be. And so, I'm a lawyer. I'm going to say it depends. That's the answer to many questions.
Well, I think also the take home is that there's no global patent, there's no global trademark, there's no global
Right.
copyright. Intellectual property is territorial. So if you want protection in a particular territory, then you need to file it in that territory. Again, you might get full faith and credit under the Berne Convention, but to actually do something against someone in a court of law in that territory to stop someone from doing what they're doing, or even to threaten to stop them to doing what they're doing, having the corresponding registration, i.e. the copyright registration in this hypothetical, in that territory, in that country, is the way to go. That's really, otherwise they'll just be like, well, you don't really have any right to do anything else to me in a court of law, so why should I even, respond to your cease and desist or something like that? So, just keep that in mind. Nothing is global in this world,
Yeah.
when it comes to intellectual property.
Okay. Question about watermark websites that you upload your images to. Will they have any rights? Or social media sites, will they have any rights? Should you keep all your things on your own website rather than social media? It depends on their terms of use. A lot of these websites, in the terms of use, it won't say, for example, it won't say that they own the copyrights all of a sudden if you post it on there, but it will say something like they get a license to reproduce the copyright on their own website or in any embedded links or something like that. And so in a way, you are giving up some of your right. If when you post say you post a photo on Instagram, you are giving up some of your right to Instagram to reproduce the photo on their own website. And sometimes Instagram will allow embedded links, for example, in like an article, and that can cause issues. There was a court case about it recently. I don't remember exactly off the top of my head from Newsweek. Sorry, the party was Newsweek, not, the lawyer or whatever. So it gets a little bit in depth. I would say you're probably okay to post your pictures on Instagram. You are giving up a little bit of your right. It could be reposted somewhere else online, in an embedded link, depending on, also there's a court split. So you're probably okay. But if you really, really want to be careful, yes, keep it on your own website, and say on your Instagram, give like, representative parts of a photo or watermark parts of a photo, and then link to your website for the actual photo or something like that, especially if you're trying to license those photos.
Okay, we have a question. Stephen, I kind of asked those. If you have a question you want to ask live, just raise your hand like Stephen did. Stephen, go for it. Stephen Ziegler. Just unmute yourself. Sorry, just unmute yourself.
All right, very good. Thank you. Well, let's say that you create a film or a video. There's a distinction, of course, but what you're doing is you base that film or video. You're commenting on an existing article posted on CNN. And so you provide no pictures from CNN, no dialogue, no audio. But what you do is in the comments in your video, for example, like on YouTube, is that you post the URL to the actual article. Now, as a professor emeritus, it's always a good idea to be able to cite your sources. And so this seems more along the lines of citing your source, attributing your source and commenting on it rather than any type of infringement. What do you think?
Yeah, that's going to be.
I agree. Just to put FYI.
Yeah, I was going to say the same thing. I think that is kind of a quintessential fair use kind of example. That is, in terms of the first element of fair use, the transformativeness. If you're using the article, if you're using the video to critique or comment on the article or educate based on the article, that's usually what is going to be called fair use. Even if you're making some money off of a YouTube video, you can still get that under fair use. I mean, you see a lot of YouTube videos nowadays are talking about, movies or something like that. And they even use clips from the movie sometimes to talk about them. If you're commenting, critiquing, doing some kind of news reporting, that's usually going to be considered fair use. Like we were saying, a lot of these websites have tools where copyright owners can, just submit a strike on the video, and YouTube will usually just take the video down without thinking about like the legal perspectives to cover their own bases. And so it won't, you're not necessarily always going to be in the clear. This company can also still just sue you and you'll wind up having to spend money in a lawsuit, right? But in terms of the actual legal merits of what we're talking about, that's probably going to be fair use and fine. Obviously it depends on the exact situation, but generally we're going to say fair use on that.
Yeah.
I don't know if you had something else to say, David.
No, but Stephen, I think like this is such there's so many gray areas in here that we usually like create copyright opinions based on this stuff. Like, oh, I'm writing a book and I want to use these 20 references. Okay, then let's get some sort of copyright opinion based on infringement. Why does that matter? Like, why pay a lawyer to get a copyright opinion as to whether what you're doing is fair use or infringing or not? Because if you are sued for infringement, then, and the court believes that you are infringing, they will then look to your intent. And if your intent was that I relied on the opinion from the attorney, let's say that it wasn't, infringement, that it was fair use, then maybe the amount of damages you'll pay will be less. Right. So we take those things very seriously when we do those types of opinions, because they really will go to your intent, which the court will look at to determine how much damages they're actually going to award you or not. Yes, there are statutory damages that you'll probably have to pay, but there could be maybe punitive damages you have to pay if the court believed that you were intentionally, like you were going out of your way to infringe. Right. You knew and you infringed. Right. Or you didn't care to find out and you infringed. So like having an opinion, it can sometimes be a CYA type of situation, especially when you're, trying to invest a lot of money and efforts in producing something that might be questionable. Okay. Yeah. And I know you're probably saying, well, I'm not going to get a copyright opinion for all the comments I'm going to put on there, but and we get that. But you may want to get a general opinion on, what the state of the law is for, what the state of the law is based on similar situations that the court may have heard based on a similar kind of fact pattern, which probably exists. And we probably just have to do a little research there. And that might, kind of, indicate what your best practices should be going forward when you're doing, when you're kind of commenting.
Yeah. Okay. More chat questions. Someone said, can I copyright myself?
I love that.
That's a funny one. Not really. I mean, in some sense, there is a right of publicity that you have as a person. And so in some ways your personhood is protected. Not really under copyright, because you're not like, you aren't a creative expression created by a human. Okay, maybe in a very broad philosophical sense, you could say you are, but not in the copyright sense. And so generally the answer to that question is going to be no, unless you have like a more specific way of asking it.
Yeah, I mean, I guess you could take like I guess you could like do a self-portrait. You could like
Yeah.
paint yourself.
You can do a self-portrait,
Yeah.
or self-photograph. A selfie can be
Yeah.
copyrighted. You can do a
Yeah.
dance, and the dance can be copyrighted.
Yeah.
A particular move, those kinds of things, yes. But like, can you copyright your own image? No, that's protected by something else in the law, like your rights to your own image and your publicity. Someone says social media platforms are enabling theft of copyright, since they have given creators the capability to do so with meme culture, remixing other people's videos. Is it embedded in the terms and conditions? So the internet, websites and social media platforms are protected in this sense from copyright infringement by US law. There's something called the DMCA, and it protects companies who are kind of a party to infringement by hosting it on their platform, as long as they give these kinds of what we were talking about, opportunities for creators to strike infringing works. It protects the websites from themselves from liability. And so yes, in theory, they are enabling theft of copyright and stuff, but it's baked into the law that they're protected for doing so. Some people don't like it. Some people like it. It's hotly contested. Some people say that it's bad because, like you were saying, it enables widespread copyright infringement that's very hard for artists to stop. Some people like it because they say, well, we need these internet platforms to be able to kind of do things freely and not be too hampered by the law. And the more kind of freedom we give them, the more creative, the more they can progress and innovate, and it's better for the economy to kind of protect them from all the legal liabilities. That is another thing that people are talking about in the copyright sphere, but right now it's all protected.
Yeah, I think we should, we're almost at 8, we're almost at
Yeah.
1:30. I want to just thank Stephen for this. I think it was awesome. I hope we got to all of your questions. I think we did, but if there's anything that you're unclear about or want some more information, please do reach out to us. We can have a Zoom. It doesn't cost anything. We're happy to provide the education and empowerment. So let us know. Our next ESS will be the last Thursday of June, which I believe is June 27th. It's going to be really exciting. A lot of we have 3 entrepreneurs that we're featuring, 3 entrepreneurs that have kind of made their that have achieved success through software. So some of them have apps, some of them have software as a service. And so kind of everything they've had to go through to kind of launch their software, protecting it, patenting it, trade secreting it, investment, just hearing from fellow entrepreneurs like yourself and kind of what they've had to deal with. 3 great companies, really diverse companies in all different areas, but all using software as their core technology. So look out for that. Look out for the recap on this. We'll probably send it next week along with the video. We look forward to hearing from you and seeing you again next month. And for everybody out there, happy Memorial Day, and have a good long weekend. And thank you for coming out. Thank you so much. Thank you, Stephen.
Thank you. Thanks, everyone. Good to see everyone. Good questions.